Welcome back to the Law News Network. I'm Jesse Weber. You're watching the prosecution's opening statements in the Adrian Loya case out of Massachusetts. Again, this is the case of Adrian Loya, who's been charged with over 30 counts in his original indictment, including the murder of Petty Officer Lisa Trubnikova, injuring her wife, Anna Trubnikova, and also injuring responding officer Jared McDonald in a shooting rampage. And the defense is claiming insanity. We have a lot of legal questions to talk about this case. What is the standard and how do they move forward? So here to help me talk about it, I'm here with Ken Belkin. Ken, great to see you, and thanks for joining us as always.
Good to see you again, Jesse. Thanks for having me.
Of course. So here's my big issue with this, and I have to start off right off the back. Insanity under Massachusetts law is basically saying that because of a mental disease or defect, this person lacks criminal responsibility because this mental disease or defect, either they don't understand or appreciate the criminality or the wrongfulness of their conduct, or they can't conform their actions to the law. This is my problem. I want to start off right here. This guy set up incendiary devices around the condominium so the police couldn't enter. That means to me, and I would think if a juror's listening to this, he knew the police would arrive. He knew that what he was doing was against the law. He tried to prevent himself from being captured or killed. How does the defense reconcile that? How is that insanity?
I mean, everything about this case is insanity. But legally speaking, look, to assert an insanity defense, first of all, there's a burden shift. Typically, in a criminal case, the prosecution has to prove the case beyond a reasonable doubt. The defense doesn't have to prove anything. Now, when you mount an affirmative defense, such as insanity, the burden then shifts, and the defense now has to prove that this guy was insane. And what that means is, as you said before, you alluded to the old McNaughton standard. You know, we took criminal law together in law school, and I could hear Professor Turkheimer saying, look, it's the inability, due to mental defect or disease, to be able to discern that your action between right and wrong, and that your actions might be wrong. But as you said, look, this guy set up a perimeter. He set up incendiary devices. He torched his own car. He set up bombs. He did everything he could to, one, evade capture, two, to have maximum amount of time on his killing field.
Yeah, and we talked about it in the break, the GoPro camera. It's not really a GoPro, but it's a camera that he set up with to videotape what he was doing. Now, for the defense, that might work. Here's a guy who wanted to videotape the carnage that he was about to engage in.
A little crazy.
A little crazy, but at the same time, if you have someone who's more calculated, I mean, this is a guy who drove from Virginia to Massachusetts to do this. He drove all the way. He planned this out. He was very well prepared.
Very deliberate.
Very deliberate. This is obviously the clear definition of premeditated murder. Yeah. Does that hurt the insanity defense for that argument, or does it help it?
I mean, this level of premeditation, you know, it can go either way. You could say this guy is so crazy, look at all the things he did. I tend to think it hurts the defense. I think this level of premeditation, these deliberate steps, this planning, the level of planning here, and I think we've only begun to scratch the surface of his planning. They're going to get into, you know, his computer records, and they say that there was extensive research done on how to affect this plan.
And he wrote a 250-page essay about why he was going to kill Petty Officer Lisa Trubnikova.
That takes time.
That takes time, and it shows that he was calculated. Then again, I've seen cases, we're going to talk about other cases in a minute, where people have diary entries. They have reasons for why they want to kill somebody. I mean, look at John Hinckley, why, you know.
Yeah, impressed Jodie Foster.
Yeah, exactly. People have, there you go, right there. And people have insane reasons for why they do what they do, and it doesn't matter if they wrote it down or not.
Yeah.
But the insanity is such a rare defense that actually works. And
rarely works.
Rarely works. And one of the things I want to talk about is he made a full confession to police. There's officers that have testified have said that when they responded, he was very calm. That's a sign of someone who didn't really understand what he was doing, or someone who really didn't appreciate the wrongfulness of what he was doing.
Or someone that is totally at peace with his actions and doesn't care.
That's how you'd flavor it if you were the prosecution.
If I was the prosecution, I would say, look, obviously if I'm the defense, I'm going to say this guy is out of touch, but I don't think so. That's not my interpretation of it, just looking at it purely objectively, you know, if I was on the jury.
Let's play a little bit of I just want to play a little comparison here with you, okay? I'm going to list some cases, and I want you to help me compare it to this case and see what we might be able to do here. Now remember, every jury's different, every case is different. You can have someone found guilty of in one case, insane in another. But let's reconcile this while I have you here. There was a case of Lee Robin. He killed his wife with an axe and drowned their nearly 3-month-old daughter in 1988. This was out in Chicago. But instead of running from the police, he waited at the family's home. He reportedly sat at the front of the stairs and told the police the bodies were upstairs when they arrived. He was ultimately found not guilty by reason of insanity after 3 mental health experts decided he was too psychologically ill. I see comparisons to this case. Do you?
I mean, yeah, it depends the nature. Look, if his defense is going to do an effective job, from the inception of this case, they should have got him mental health treatment. They should have brought him before a psychiatrist that would give him diagnoses that would indicate he has a very, very severe mental illness. You know, paranoid schizophrenia, some sort of severe bipolar, something of that nature where his perception of reality is extremely warped. They would need to get that into evidence.
I think we're going to see that later on, but the idea of you have this guy who basically sat at his home waiting for the police. You had Adrian Loya waiting around, was calm, knew what he was doing, waited for the police.
But my problem is, in the opening statement, the best the defense could come up with is that this guy is possibly on the autism spectrum.
Right.
That, you know, look, autism is a horrible condition, but I don't know that people who are autistic can't appreciate the fact that murder is wrong.
And let's break that down, because what they're going to argue is autism or Asperger's, they would say legally, is a mental disease or defect. And it's that mental disease or defect that caused this person to not understand or appreciate the wrongfulness of his action. That's a leap.
That's a very big leap. Personally, I think there's only a handful of mental illnesses that really alter one's perception of reality to the point where they cannot tell that, as in this case, murder is wrong. Yeah. And that's the key here. They have to be able, their perception has to be so skewed that they can't tell the difference between right and wrong, and they can't appreciate that taking another human life is wrong.
I saw a statistic that nationally defendants enter not guilty by reason of insanity pleas in fewer than 1% of the cases, and the American Academy of Psychiatry reported that only a quarter of those were actually successful. So,
yeah, the statistics don't bear it out being used successfully.
So okay, the way that I've understood the insanity defense, the way that people bring it up is you really have to have a warped perception of reality. And I want to give you another case and help me explain it. This is actually out of Massachusetts. Michael Muko McDermott, a support employee, shot and killed 7 co-workers at Edgewater Technology in Wakefield, Massachusetts on December 26, 2000. He claimed he traveled back in time and killed Hitler and the last 6 Nazis. You would think he'd be found guilty of, you would think he'd be found criminally insane. He was found guilty of 7 counts of first-degree murder and sentenced to 7 consecutive life sentences without the possibility of parole. There you have somebody, if you believe what he's saying, and I don't know the specifics of that case, but that's standard where somebody really had a warped perception of reality. Yeah. That seems clear-cut insanity. So how does Adrian Loya even have a chance?
Well, look, we don't know what mental health experts testified in that case. But, you know, clearly, if they were able to elicit evidence from mental health experts that would indicate that he had very severe schizophrenia and that he truly believed this bizarre hallucination that he was sent back in time to kill Hitler and the last 6 Nazis, you know, I think, look, if that's not successful, what is? And there's a lot of research that indicates juries are very reticent to believe in mental illness to that extent. It's very hard, you know, to put yourself in someone else's shoes when those shoes are like, you know, filled with delusions of grandeur and hallucinations and paranoia.
Right.
It's hard to relate to as a juror.
We're going to turn now to the next part of the prosecution's opening. I have more questions for Ken about what would happen if he was sentenced to a lesser degree, what would happen if other evidentiary issues in this case. So, though you're not going to want to miss this, we talked a little bit about the insanity defense and what that means from a legal standpoint. Let's continue on with the prosecution's opening, and then we're going to be back here with Ken Belkin to talk a little bit more about the legal standards.
Folks, good afternoon. We spent a few days together once again. I'm Bruce Segadelli, and I'm here on behalf of Adrian Loya. Being a part of what we did the last few days, you saw the pains we take in the impalement process. The theory behind that obviously is we want to seek you heard the judge use the impartial jurors. We likewise would like to believe that any preconceived bias or prejudice are essentially left at the courthouse steps. But we don't ask any jurors ever to set aside their common sense. Like Mr. Glennie, as His Honor told you about keeping the open mind, I will likewise do the same thing. But I will ask you throughout the trial to still utilize your common sense and exercise that gained through life's experiences. Now, it's a challenging case. We're going to be applying the same principles of law and so forth as one would in a trespassing case or a capital case of this nature. But it is still challenging. And as we all know, utilizing common sense, and the judge will tell you eventually that the Commonwealth, and you've all heard this, bears that burden of proving the case. That proving the case beyond a reasonable doubt. And I'll just submit to you early because we're not arguing now, we're just hopefully helping you. But it is a significant burden. And you heard somewhat in the impalement process that it isn't only proving beyond a reasonable doubt that that fellow did these terrible, tragic acts. It's not only that, but they also must prove beyond a reasonable doubt that at the time of this conduct, that he, as a result of mental disease or defect, did not appreciate the wrongfulness of his conduct, or that he could not conform his conduct to the requirements of law. I'll submit to you, some people use the expressions, who done it? Though this isn't the case, you're going to see an abundance of evidence, a great majority of which came from that fellow, my client, as he wrote a 265-page document about this plan, as he wrote letters to Lisa, some 23 pages before this event. You're going to hear that some of this plan, or this planned mission, could have gone as long as 16 months, the planning stages, that it was meticulously planned, meticulously detailed in each and every nature of it. Listen for that. Not only that, what he left in the paperwork, but when speaking with the police officers on 2 different occasions for hours. And you'll have the opportunity to hear that. And I'd ask you to pay particular attention, not only to the acts that occurred on his birthday, somewhat unusual, February the 5th, 2015, his 31st birthday, but the specific detail in the 265 pages, in the detailing it to the police, because I'm going to suggest to you that's all going to wind in to his disease of defect. That's not the legal label. It ultimately will be for you, but how do we go there? Now, keep in mind, as the judge has instructed you, the defendant doesn't have to do anything. Why is that? As the judge told you, he is presumed innocent. But I think the evidence is going to show you and lead you down a particular path. And we have witnesses, and I anticipate you'll hear from witnesses in this case. And some use the expression expert witness. That's really where you become the judges. It will be for you to determine whether or not you accept or exclude. They're not given any grace because they're termed this, or they have a particular profession that could help give credence to their opinions. But you'll hear from I anticipate you'll hear from a Dr. Daniel. Let me step back. Experts, as one utilizing common sense could assume, they base their opinion on their database or the accumulation of all information they can utilize to draw their conclusions. Well, you'll hear from Dr. Daniel, you'll hear everything he utilized to form his opinion. Not only were there police reports and 265-page document, and police reports speaking to collateral families, speaking to the Coast Guard and their investigation, speaking to the lawyers perhaps. He spent some 43 hours, the evidence will show you, with Mr. Loya. Some 43 hours. And he's going to suggest to you that he suffers from a significant mental disease or defect that both deprived him of the ability to conform his conduct to the requirements of law. And we go with that, what's called the McCool standard, appreciate wrongfulness, conform conduct. He's going to suggest to you, and that standard, ladies and gentlemen, is given to us in the alternative. So it's not and, it's appreciate wrongfulness or conform conduct to the requirements of law. Dr. Daniel, after spending all that time, you'll have the ability to praise him like us. You'll also hear from, and I submit to you, Dr. Daniel has a significant amount of experience, but you'll also hear from a Dr. Martin Kelly, who has a long history in testifying and so forth. You may hear such evidence that he has testified in some 300 to 400 cases. That he was originally hired. The court eventually asked him to speak to Mr. Loya, and he spent better than 9 hours with Mr. Loya. And pursuant to his training and experience, he's a psychiatrist. He said, somewhat of a different label, where Dr. Daniel gives some type of delusional label, but it's a significant mental disease or defect. Dr. Martin Kelly suggests that it's on the autism spectrum, in fact, perhaps a high-functioning Asperger's. And because of that, and likewise, he suffered from a delusional base on that particular day. We're focusing on that day, February 5th, because it's at the time the conduct is committed, that he could not, Dr. Kelly could not conform to the requirements of law because he was in a delusion. In fact, it was in his mind, Dr. Kelly, I believe the evidence will show, it was a good against evil scenario. You're going to hear what was occurring in his head in that particular day. That's why I said it's a challenge. This case is going to be a challenge. It's not the whodunit, but one has to look seriously at this testimony about what was going on. What was he doing in the planning stages? What caused him? What motivated him to do all this? And what was it as a result of? You're going to hear from there's a Dr. Holtzman, I believe, who works for the state, not wholly convinced of a mental disease or defect that would give or deprive somebody of the ability to conform their conduct. But what we'll also look to, and the evidence may show you that Dr. Holtzman didn't have that database I talked about, police reports. I don't think he had the ability to see Dr. Kelly and Dr. Daniels' reports. So one might suggest his foundation was not sound enough. Eventually hired years after this, and I would just submit to you at this time an opening statement. The most important time is the event sometime after 2 a.m. on February the 5th. In fact, the first call came into 911 at 2:11. Mr. Loya was taken into custody at 2:48. So there's roughly 36 minutes that's involved here that we're going to be looking at, and they ask you to keep an eye on. But you're eventually going to hear, I believe the evidence is going to show you, you're going to hear from a Dr. Ida Shine, who was eventually hired to give an opinion. And she gave an opinion. Once again, I'd ask you to look at what type of database does she have. She had a period of better than 8 months to go and visit and see Mr. Loya. One would hope to assist her in her evaluation of him. She never took that opportunity. But in light of that, she'll suggest to you he could conform, or he doesn't meet the standard. Why you can say that, I'd ask you to keep an open mind. The judge will tell you. That's ultimately up to you. Those folks, even if they're labeled the experts of the case, it's going to be up to you, ladies and gentlemen, to make that determination. And she never, Dr. Ardisha never availed herself of that. Again, the whodunit aspect, keep an eye on where it came from. The vast majority came from Mr. Loya, because it's part of that delusional base we're starting with. And I'll eventually ask you to look, when you deliberate, look at all of that evidence to see that first aspect of that burden that Mr. Glennie has to carry from start to finish. Yeah, I want to probably get over that first But the second, at the time, and that's why it's such a challenge, at the time that he could conform himself, that he appreciated the wrongfulness, and I would submit to you at this stage that he could not. And after that challenge, one will submit that the Commonwealth could not get over that burden of proving the case beyond a reasonable doubt. Thank you.
Welcome back to the Law News Network. I'm your host, Jesse Weber. You were watching the defense's opening statement in the Adrian Loya case out of Massachusetts. Again, this is the case of the former Coast Guard member who is accused of forcibly entering the home of Petty Officer Lisa Trubnikova and her wife, Petty Officer Anna Trubnikova, and going on a shooting rampage, killing Lisa, injuring Anna, as well as responding officer Jared McDonald. Prosecutors said that Loya videotaped his rampage with a camera attached to his clothing and set explosive devices around the condominium complex to prevent police from responding. He's been charged with 30 counts in his original indictment, including murder, and now, as the defense is trying to do, as you heard in their opening statements, argue the insanity defense, namely that he is not criminally responsible because of a mental disease or defect. He could not appreciate the wrongfulness of his actions. So, here to help me talk a little bit more about this, I'm with Ken Belkin. Ken, we were talking a little bit about that standard earlier, uphill battle for the defense. Again, as we talked about in the break, this is not an easy case for the defense, and I don't know if you would want it.
Not an easy case for the defense. Look, this is like practicing with a medicine ball. If you can handle a case like this, you can handle anything. And if you can handle a case like this successfully, well, your jersey or your suit should probably be retired in the Lawyer Hall of Fame.
That's a nice analogy. I like that. But here's what I'm curious about. You have jurors. They're going to be hearing this case. Having them have a unanimous verdict might be difficult in this case, and trying to prove beyond a reasonable doubt that Mr. Loya is criminally responsible might be tough. Is it possible that we would see something that he would be found guilty of a lesser degree of murder, not taking away the other counts that he's charged with, the other 29 counts, but found with a lesser degree of murder, sent to prison, receive psychiatric treatment, and then possibly in the future be released? Because I don't know if I want to just remind our viewers, there was an issue with John DuPont. I'm sure it was the focus of the Foxcatcher movie. He had shot and killed someone, and as part of the jury's agreement that DuPont was mentally ill, he was ordered to receive psychiatric treatment while incarcerated, and he was spared a life sentence because he was mentally ill. He technically could have been released in as little as 5 years, but he passed away in jail. Do you see a situation where it's possible, Adrian Loya, but he's charged with 30 counts of all various crimes, he could be sent to prison, receive psychiatric treatment, maybe not get a life sentence, and eventually be released? Is that a possibility?
Well, I don't want to speculate as to his sentence. That's really the judge's job. There are mitigating factors here that would indicate he should get a lighter sentence. But given the level of seriousness of the offense, I don't know how much mitigation is going to be effective. Look, he is a Coast Guardsman. He served this country proudly, bravely. From what we see, no other criminal convictions. So he's got some good things, in column A. Column B, however, egregious crimes, the strength of the evidence. I mean, if you ask me, this guy's going down for first-degree murder. This is textbook premeditation, the planning of the improvised explosive devices, setting his car on fire as a distraction or a barricade to impede the police's ability to respond. Everything about this screams textbook first-degree murder. And by the way, you look at him sitting there in the courtroom, he doesn't look crazy. He doesn't look remorseful. He looks a little scared that he's going to face the logical consequences of his actions, but he looks, for lack of a better term, looks like a creep.
Well, if you look at him and he's showing no emotion for what's being said, that would indicate to me, for the defense, this is a guy who didn't really appreciate what he did. Was that wrong or criminally, against the law? This is a guy who's cold inside, who doesn't really see it. He's like, okay, I did it. I don't really see what the big deal is. That's what it looks like to me. That's the way maybe a juror would look at it.
Or he just doesn't care. He's a psychopath and doesn't, value human life the way society and the rest of us do.
Now, he has actually been remanded to Bridgewater State Hospital for the last 2 years since his arrest. Bridgewater State Hospital, it's located in southern Massachusetts. It's a state facility housing the criminally insane and those whose sanity is being evaluated for the criminal justice system. If he is in fact deemed to not be criminal responsible, the jury finds that he is criminally insane, is it possible that he would be remanded there, stay there, and eventually be released through that mechanism? In terms of if you are sentenced, if you are found to be criminally insane, sentenced to a mental health facility, is it eventually possible that you can be, for lack of a better word, cured and eventually be released into the community again?
Yeah, absolutely. You can be evaluated. You can be held indefinitely at these facilities. That's the downside to it. It's not like with incarceration where there's a definite sentence and the possibility, of getting off early, paroled for good behavior and whatnot. But with these facilities, you could be sentenced there indefinitely and treated what could amount to indefinite detention. But yeah, there is the possibility that at a certain point, if his treatment progresses and it's successful, doctors deem him not a threat to himself or others, he could be released.
Yeah. Again, I still feel that him knowing the police were going to arrive, creating a barricade, shows that he understood the wrongfulness of what he was doing, showing that what he knew he was doing was illegal. I think that's going to be the biggest barrier for the defense. Then again, I'm very curious to hear that 250-page essay that he wrote about why he wanted to kill Lisa Trubnikova. But I do want to turn our attention to something that the defense had brought up. The prosecution retained Dr. Martin Kelly to evaluate Adrian Loya, and Segadelli, who is the defense's defense attorney, he referred to Dr. Martin Kelly as an agent of the prosecution. He filed a motion to have that interview recorded so a jury could review the actual conversation between Loya and the psychiatrist as opposed to just hearing the doctor's testimony. Now, the judge in this case, Judge Gary Nickerson, said he had seen, in the past, he'd seen positive results from having evaluations recorded. But he denied the motion. And why did he deny the motion? Because he said that the interview by the defense's expert was not recorded. And now the defense's attorney's request to do this, to have this recorded, is just it's a one-upmanship. It's not about fairness. Two questions for you. What is the value, if you can explain for our jurors, for our viewers, the value of recording that conversation as opposed to just hearing the doctor's testimony? And two, do you agree with the judge's ruling?
Well, you got to unpack that a little bit because I think on one end, it is valuable to see these interviews. On the other end, the point of this doctor's testimony, it's expert testimony. It's to help the jurors evaluate something that is beyond what they call the ken of the average juror, no pun intended. But, the expert is supposed to help the jury understand and evaluate, like give his opinion, let them know things that the average juror might not know about mental illness, his condition, and his analysis. So to a certain extent, I feel like the video sort of intrudes on the expert's ability to do that because jurors are gonna gain their own insight from the viewing of this videotape, and they bring their own prejudices and biases to it. With the expert testimony, it's a little bit more clear cut. On the other hand, it is valuable to see the way the interview went down, to see, the defendant's mannerisms, his demeanor in that video. It could be helpful in rendering a verdict. But I do think it is interesting, an interesting play on the defense's part, that they would request the prosecution's medical expert interview be taped after they had already conducted theirs, so there was no possibility of theirs being taped.
So you think it's a little bit one-upmanship?
It's a little bit one-upmanship, but everything in a trial is a game of one-upmanship, essentially.
Yeah. It's interesting because we see, how many times have we seen, especially on this network when we cover other cases, videotape confessions or videotape interrogations with police. We watch that. We don't just hear the detective's testimony, we watch the video. We saw it in the David Criado case, the DJ Criado case. That was a big part.
The difference there is, those are facts that need to be laid into evidence. That it is a fact that this person was interrogated, and during the interrogation, he confessed. These mental health interviews, it's more of getting the opinion of the mental health expert.
Right.
It's not so much the facts.
Right, because again, this is not an issue about who done it.
Yeah,
we know what he did.
Certainly not an issue.
We know what he did. It's all about, is he criminally responsible under the law. And again, the standard that we've talked about here, and just to give you a little bit of a little bit of a summary, a person would be lacking in criminal responsibility if he or she has a mental disease or defect, and Ken and I talked about it, that the defense is trying to say one of their options is that he might have had Asperger's or autism, and as a result of that mental disease or defect, he did not substantially understand or appreciate the criminality or wrongfulness of his actions or his conduct, or he could not conform his conduct to the requirements of the law. And as we said, based upon the premeditation, based upon the fact that he created a barricade, based upon all of these factors, it seems that the idea that he was truly criminally insane might not fly.
Yeah, I mean, it's interesting. It's almost insulting, the defense's theory, to people who suffer from autism and Asperger's, to say that just because you have autism or Asperger's or you're on the spectrum, that you can't, you don't appreciate the fact that human life is valuable and that murdering is wrong. It's a little bit insulting,
and it's a stretch. It's a stretch.
Big
They're picking at straws, but this is what they have to do. And again, trying to argue insanity, it's rarely pled, and it's rarely successful. So we'll have to see. But before we turn to our next clip, which is going to be one of the officers who testified earlier in the week, I want to ask you about the surviving victim, Petty Officer Anna Trubnikova. That is the wife of the victim, Lisa Trubnikova. Would you put her on the stand? I mean, this is not a question about who committed this crime. This is a question of whether or not he was criminally insane when he committed this crime. Would you put her on the stand knowing that this is going to be a very traumatic experience, her being on the stand and recounting the events of that night? Would you do it?
I mean, I think from a prosecution standpoint, they don't necessarily need her, but I think it does strengthen the case. Look, even though there's video, he took a GoPro on his little journey down crazy lane. You know, not to make light of it,
sure,
but you know, in this business, you got to keep a sense of humor and be human. But look, the video didn't record any audio. She's the only one that can testify to things he might have said, to his demeanor, because the video doesn't capture, you know, his demeanor. It just captures the actions. So I think her testimony is useful, especially in establishing if they want to try and defeat the insanity defense and say, look, this guy knew what he was doing. He wasn't crazy. He was just angry.
Yeah.
He was just, you know, he was just acting in a very violent manner.
Yeah.
And he knew what he was doing was wrong.
Right.
And I think her testimony would be very helpful.
Okay, well, we'll have to see. Let's turn to the testimony, the prior testimony of Officer Joshua Parsons. We're going to look at that again. We're waiting for some live feed in the courtroom. Again, the jury will probably go on a site visit today of the condominium where this whole event took place. We expect some activity. We'll turn to it once we have it, but in the meantime, we're replaying some of the clips you might have missed. So here's the beginning testimony of Officer Joshua Parsons. And again, when you watch any of the testimony here, the idea is what they testified to. Was Adrian Loya criminally insane, or is he criminally responsible for what he did? Take a look.
A voice. Could you state your name and could you spell your last name?
My name is Joshua Parsons, P-A-R-S-O-N-S.
I mean, he's definitely.
And how are you employed, sir?
I'm a police officer with the Bourne Police Department.
And how
Okay,
long have you
Judge-
served with the Bourne Police Department?
Roughly 5 years.
Now, drawing your attention to the date
Thank you.
of February 5th of 2015, were you on duty on that date?
Yes, I was.
And what duty were you assigned?
I was assigned to patrol the Pleasant Space Center for Bourne.
And how were you dressed when you went for to do that shift?
I was dressed in our blue duty uniform, badge, gun belt.
And did you have a car, or were you with somebody else?
I was alone in a marked cruiser.
All right. Now, drawing your attention to at or around 2:12 in the morning, did something take place or happen?
Around 2:12, I was dispatched to Roundhouse Road for a reported car fire.
Everybody
and a
loves
second
your
report
comment.
of gunshot
Yeah,
victims
it's very
at
insulting.
number 11 Roundhouse.
What did you do after receiving that call?
Drove to the scene, and arrived with several other officers. And as soon as I arrived on scene, I saw a burning sedan parked perpendicular with the road, made it impassable for any vehicles or pedestrians.
Now, when you say burning vehicle, could you be any more specific?
A vehicle was fully involved. Windows were all blown out, tires were flat.
Okay, so,
Burning that you could get without being totally burned out.
so it wasn't a minor fire, this was a totally engulfed car.
Fully involved, yes.
Now, you said that you were a police officer for 5 years up to today?
Yes, sir.
And would that Roundhouse Road area be part of your patrol at times, being a police officer in Bourne?
Yes, it is.
If I might approach, please, ma'am?
Please.
If you'd be kind enough to look at these two photos and just referring to what's marked as A, do you recognize what that is?
Yes, I do.
And what is that?
That is the Roundhouse Road condominium complex.
And that's taken from the air, of course.
Yes, it is.
In photo B, is that just a same area from a different angle?
Yes, it's from a different angle.
And would this be consistent with what the weather conditions were at that time?
Yes, it's very snowy.
You know how to offer this?
Offered.
Okay.
Exhibit 1.
May I publish it to the jurors? So that-
Well, you can show it to them. Well, let my clerk mark it. Jurors, anything that's marked as an exhibit, you're going to have in the jury room during your deliberations to examine to your heart's content. So if you just get a quick look at it in the courtroom, don't worry, you'll have it to look at as long as you want.
So now, when you just indicated that you came into the complex and there was a burning vehicle, could you point on the map as to where that would have been located?
You're blocking some of the jurors, Mr. Lindsay.
All right.
Yeah, you are.
The vehicle would have been parked approximately right here across the road, right near the bed.
Okay. And if you could just show that would be in photo B.
Be right about here.
Thank you. And as these photographs show, that roundhouse complex, how many ways were there to get into it?
It's only single access, there's one road in.
And that car was blocking that access in egress?
Yes, it was.
So you drove with your cruiser to that area, and what happened?
Parked approximately about 100 feet back from the fire. There were several other vehicles there already from my department as well as fire department. Walked up near the vehicle with other officers, immediately noticed that there was a object in the snowbank to the right near a fire hydrant. It appeared to be an IED of some sort.
Okay, what do you mean by IED?
Some sort of improvised explosive device placed in the snowbank near the hydrant. Looked like a couple of soda bottles filled with small items and then had wires on it.
Okay. If you be kind enough to look at this, where do you recognize?
That was the,
Okay. You photographed me, that's what you saw when you were, right?
yes, it is.
Assistant marker ID is pretty much.
Mark for identification.
That'll be identification of the,
Jurors, when something's marked for identification, that's how we keep track of it in the stenographic record. Maybe it'll become an exhibit, maybe it won't. We'll have to wait and see.
In any event, exhibit, I'm sorry, item B, here, that's a very accurate depiction of how that looked, is that correct?
Yes, it is.
So I move to offer B at this point as an exhibit, even on this until the whole thing is just through the ways.
Then it remains for identification, if you're not going to single it up. And frankly, if it's not in the exhibit, you turn it around so the jurors aren't viewing it. The jurors see what's an exhibit, not what's being marked for identification, until it matures, if it does, into an exhibit.
Welcome back to Law News Network. I'm Jesse Weber. We were covering the Adrian Loya case out of Massachusetts. The jury is going on a site visit today to see the condominium where this entire shooting rampage took place, where Adrian Loya, who's a former Coast Guard member, shot and killed Petty Officer Lisa Trubnikova, injuring her wife, Anna Trubnikova, who's also a petty officer, as well as injuring Jared McDonald, who was a responding officer. I'm here with Ken Belkin. Ken, we were talking about everything in this case, specifically the legal standard about, is this person criminally insane? Because that is what the defense is putting forth, that this person is insane under the law, didn't appreciate the wrongfulness or criminally legality of what he did. He didn't appreciate it, couldn't understand it, and therefore should not be found guilty. But what we were actually talking about was testimony. And who would you put on the stand? We talked about if you would put Anna Trubnikova on the stand, who's the surviving victim in this case. But we talked in the break about, would you put the defendant on the stand? Now, defendants have been put on the stand, from what I've seen, usually in self-defense cases. We want to understand what they were thinking. Why would they do what they did? Yeah. This is a little different, but you would put them on the stand or not?
I mean, look, the general consensus right now among defense attorneys in this country is you do not put your client on the stand. It's been the general consensus for a long time. Now, there's a lot of research that suggests, research that's relatively recent, that suggests even though jurors are instructed that a defendant is under no obligation to take the stand in their case and that they cannot hold it against the defendant for failing to testify and take the stand, the research indicates they still do. And that makes sense. On a common sense level, this person's accused of a crime. Well, I want to hear from him. I want to hear what he has to say for himself. It's natural human curiosity. And I'll tell you this, just anecdotally, the reason you don't put defendants on the stand typically is if they have prior criminal convictions, because they will be able to be questioned on those criminal convictions. And the idea is that a juror hearing about prior criminal convictions, it's too prejudicial to the defendant in the current matter, in the current trial. Now, I've had success with putting defendants on the stand. I've done 7 trials, lost 1. The one trial I lost was the one trial where my client did not take the stand to testify. Now, I know that's just anecdotal, that's just my experience, but I think it's telling. I think jurors often really do want to hear what a defendant has to say. And I think in this case, he's not a bad defendant to testify. Yes, he is accused of horrible, horrible things, and no one's disputing whether or not he did those things. He clearly did those things. But I do think if we're going to talk about his mental state and his ability to appreciate the difference between right and wrong and be able to discern if murdering people is wrong, his testimony to that effect would be useful.
I'm going to ask you this, though, about that. Isn't a lot of times when defendants take the stand, it's in cases of saying, I had nothing to do with this. I had nothing, I was here. I was here at this place, I was here at this place, I have no reason to do this. And the danger, I would assume, besides the dangers that you mentioned about putting a defendant on the stand about their criminal record, they could be lying, okay? So they could be lying. You catch them up in a lie. You under cross-examination, their stories don't match up. Here, you wouldn't have a situation where, again, who done it? We know he did it. Yeah. It's not about that lie. How would the prosecution put him on the stand? Excuse me, how would the prosecution cross-examine him in a way that would say he's not being entirely honest or truthful about whether or not he was insane or not? You see what I'm saying? I'm saying, well, how would you trip him up if you're the prosecution? You put him on the stand. How would you say, okay, let's back it up. You really want to claim he's criminally insane, he didn't appreciate the wrongfulness of his actions. If I were doing it, I would say that, why did you set up a police barricade? Why did you set up a barricade for the police if you didn't think it was a problem?
And in fact, the prosecution's got a lot of material to work with on cross-examination. They've got the interrogations. They've got the records of the mental health interviews. They've got his 250-page, manifesto, if you will. They've got a lot of material to cross-examine him on, and that is the downside here. So, maybe I'll walk it back. Maybe it's not great to put him on the stand because there's so much stuff to cross-examine him on. But however, really, I think it's a gamble between that and saying to yourself as the defense attorney, who is the best person to tell the jury about the mental state of the defendant. The defendant, he's the one who could testify to be like, I really didn't understand what I was doing. I was out of control, you know. But I don't think people are going to believe that someone who suffers from autism is that out of control.
And let's talk about, you mentioned it briefly before, he was in the Coast Guard. The hiring standards. If this is a guy who really suffered from a serious mental disease or defect,
They would have weeded him out.
Wouldn't they have weeded him out? I mean, this is 2 years ago. I mean, I don't understand how that would have been possible. I mean, I would imagine whenever you are going under an examination for a government position or something in some sort of capacity like that, there's a psychological evaluation.
Yeah.
So how does that make sense? How do you reconcile that if you're the defense?
I mean, I think the defense has really got an uphill battle here. I am not, you know, I'm really not admiring the position they're in right now. This is a very tough case.
Yeah.
This guy, and he doesn't come across as particularly sympathetic either.
No.
He sits there in the courtroom. I mean, this guy
you see the
looks
image of
like
him
a murderer.
Yeah.
You know, he looks like he looks like someone you would imagine enjoys taking human life.
Yeah. Well, that's what, at the end of the day, you have jurors who are read the law. They know what they're supposed to decide, but they're they know what they're supposed to decide based upon the law, but they're human beings.
Yeah, I think the defense attorney needs a little bit of a stylist on this case. They need to soften this guy up.
Yeah, a little bit.
Put the nerd glasses on. Give him the combed
You mean
hair
make
look.
him look a little more crazy?
Make him look just a little crazy, but a little bit like, you know, unassuming.
Yeah.
Because this guy, he looks like a killer.
Yeah.
When I see him, you know.
Yeah. Well, I can't deny what he did.
Yeah, can't deny what he did.
Question, evidentiary question for you. The GoPro camera. I say GoPro camera, even the prosecution said it's not really a GoPro camera, but it's a camera that was attached to his body that videotaped the entire footage. When that is presented into evidence, is there any kind of evidentiary issues that would result from playing a video in the courtroom? Or that you might raise if you're the defense?
I mean, they're going to have to get it into evidence. They're going to have to lay the foundation, or the defense is going to have to stipulate to it being admitted into evidence, which if I was the defense attorney, I wouldn't stipulate to anything in a case like this, because whatever you can do to fight this, you got to fight this. But I think, you know, the arresting officer retrieved it from him. It was on his person. I think they could lay enough of a foundation where the footage is admissible.
Right. All right, Ken. Well, we're going to stick with you. We still have you here for some time to talk a little bit more about this case. And we're going to turn continuing coverage of the testimony of Officer Parsons, who was one of the responding officers at the scene of that night. What is interesting to take away from this is his perception of the defendant, Adrian Loya, which is going to be very key in this case. What was his demeanor? He was calm. He was responsive. Ken and I have talked about that. What does that mean for the criminal insanity defense? So take a look at this. Ken and I will discuss it more. We'll continue our coverage here on Law News Network.
Taking the observation of that item, what did you next do?
At that time, we still needed to enter the complex because of the shooting victims in number 11. So we had a plan to split into two-man teams and go around the vehicle and the possible explosive device through the woods using either side of the road.
So what happened next?
Myself and another officer, we had gone to the right side of the road. Because of the snow and the terrain, we had to go about 50 feet off the road into a gully through about 3 feet of snow and travel up the road till we passed where the burning vehicle was to our rights at this time. Then we entered back onto the road about 75 feet past the burning car.
Okay. And were you able to see that burning car after it was no longer burning?
I did not see it after it was still burning the whole time I was there.
What's the next thing that happened after you? Who was with you? Do you remember?
Also the servant was with me.
So you guys came out on the other side of the car?
Yes.
What's the next thing that happened?
At that point, we moved up to a fork in the road where the road can either go, it's a large circular complex, and we were going to go to the right because the other officers, we had planned to go to the left. So we got to the fork in the road and tried to find some markers for the houses, but in this case, the markers are short markers. They were actually in the snow. So we were kind of trying to get our bearings as far as where we were in the complex.
All right. So is it fair to say at that point you didn't know which way 11 was?
No, I did not.
Okay. So what happened next?
During that brief pause, I heard a short burst of gunfire, followed by a radio transmission from Officer McDonald stating that he had been shot in the back and that he couldn't use his legs.
And do you know where Officer McDonald was?
At that time, the last I had seen him, he was in the parking lot downhill to the right, to the left, sorry.
Okay, so when you had indicated that you had broken into two groups of two, was he in one of the groups?
He was in the second group of two. He was with Officer Leavenworth, and they had come through the woods on the left side of the road.
Okay. So what did you do?
At that time, I started to advance towards his position to try to render aid to him, and also look for the gunman that shot him. Because of the way the development's built and the way the snow was, we were walking down the center of the road under streetlights, and we didn't at this time know where the gunman was. Realizing this and that we were putting ourselves in danger, we backed up the road, myself and Officer Lacerda, and there's a large metal dumpster just off the fork in the road, and we took cover behind the dumpster until we could get a better bearing on where the gunman was.
And what happened next?
At that time, the more backup had arrived, and radio transmissions could be heard that they were coming up through the woods, following the same path that Officers McDonald and Leavenworth had taken to get to his position and help him. And that's when several officers started shouting that they had a gunman coming out of the woods towards them.
And what happened next?
I saw a deputy in canine come out of the wood line, or correction, out of the parking lot where Officer McDonald had been shot. As he came out, he called for support of a long gun, or a rifle, in other words. At the time, I was carrying a rifle, so I advanced down the road to provide him cover as he tried to go towards the suspect in the road as well.
Did you see somebody at some point?
As I came down the hill, I could see a gunman walking down the hill with his hands up, and I could see, I believe it was troopers on the left-hand side of the road, shouting at him to keep coming forward and keep his hands raised.
And what happened next?
As I came down to the deputy and the canine, we moved forward, and we took over command to bring the suspect down the road and prone him out in front of us, or have him lay down on the road so we could handcuff him, or I could handcuff him. At that time, I did that.
Okay, and then what happened?
After handcuffing him, I searched him for any sort of weapons or anything that could hurt myself or other people around me. I removed a large folding knife from his right front pocket. He had tactical style, like BDU style pants on that the military would use, and there are dedicated pockets in the front that hold rifle magazines, and he had a rifle magazine on each side. I also removed 2 smoke grenades out of one of the right cargo pockets, and 2 small devices that I believe at the time were detonators out of a left side pocket, I believe.
Okay, were you able to determine at some point whether they were or were not detonators?
I was later determined that they were not. There was some sort of internet brand rape alarm or something like that that would emit a loud sound and a flashing light when the button was pushed on it.
And what's the next thing that happened after that?
I took those devices and I put them in a snowbank near us, because at the time I didn't know what they were, and I took and dragged the suspect off the road into cover, into the parking lot, which is just to the left of where I was standing, so that we weren't in any line of fire. Because at the time we were getting multiple calls through 911 that were being relayed to us for a second gunman in the complex.
If you be kind enough to look into this back, if I'm not approaching.
Council do not need to ask permission to approach. You approach at will, and if you overstay, you're welcome. I'll be sure we'll be back.
Could you look at that and tell me if you recognize what that is?
That's the device, what we believe was a bomb that was placed in the snowbank.
What do you believe? It's the device you saw.
Yes, sir.
I would offer this one.
Offer.
No objection.
Next number exhibit.
I don't know if we will take it out and start to do something else or just leave it.
For a moment, we'll identify it as an exhibit in that bag, and council, after you've had a chance to inspect all the exhibits, you may change the bags if necessary. All right, it will still have the same number. If it changes bags, it will be exhibit 2.
Welcome back to the Law News Network. I'm your host, Jesse Weber. You're watching the testimony of Officer Joshua Parsons in the Adrian Loya case out of Massachusetts. Now, this is the case of the former Coast Guard member who shot and killed Petty Officer Lisa Trubnikova and injured her wife, Anna Trubnikova, and injuring Jared McDonald, who was one of the responding officers in a crazy shooting rampage. And what you just heard from Officer Joshua Parsons, he was talking about what he found as a responding officer. He said, Parsons said there was a burning car that blocked the only entrance to the condos. Remember, the defendant here set up incendiary devices around the condo so that the police couldn't get through. He also testified that he noticed an IED, an incendiary device, in his snowbank near the car, and he said a couple of soda bottles filled with small items, and it had wires on it, describing what turned out to be a hoax bomb. Eventually came down, the defendant came down with his hands up. They moved forward, they searched the defendant, they cuffed him. He had a tactical vest, smoke grenades, other devices believed to be detonators. They emitted sound and flashing light. And then, this is a whole discussion about what this guy was operating with. So the question becomes, as the defense is put forward, was he criminally insane? Did he not appreciate the wrongfulness of his actions, and should he not be found guilty because he's not criminally responsible under the law? We've been discussing this all morning, and I'm here to again talk about this with Ken Belkin. Ken, we've been talking about this the entire morning. Again, the idea that he was so premeditated, that he was armed for battle. He had a camera on his vest, his clothing. He knew what he was doing. He set up a blockade to prevent the police from coming forward with incendiary devices. He lit his car on fire. Crazy behavior, but does that fall under criminally insane under the law?
I mean, look, well, we discussed a few other things in the break.
Yes.
But we won't get into that. But look, this behavior, yes, to the average observer, it's crazy. But is it indicative of someone who did not appreciate the difference between right and wrong in his actions? And I don't think so. As we've said several times, the barricading, the explosives as a distraction, everything he could to impede the response of law enforcement that he could do, he did. The camera, he wanted to document this, the manifesto. Now look, maybe the defense can elicit some sort of testimony indicating he was suffering from some serious paranoia, he had some delusions or hallucinations that led him to do these crazy things. But given their opening argument that autism is their trump card, I don't know that they're going to get there. There's no paranoia, there's no delusions with autism.
And I'm not 100% sure, but I don't believe that this defendant has had a history of mental illness where anything like this has happened. He was in the Coast Guard.
Yeah.
He was in the Coast Guard. He would have had a psychological evaluation, you would presume.
Yeah.
So the idea that this happened and now all of a sudden he's insane, obviously, yes, let me rephrase. There are certain times in people's lives when they go through a psychological event, their concept of right and wrong, their delusions, that might happen at a certain point. But to have this happen here doesn't quite mix with other cases that we've seen. Now, I just want to ask you a question. Loya, he's been at Bridgewater State Hospital, which is a mental health facility in southeastern Massachusetts. He's been there for 2 years since his arrest. Now the question becomes, does he go back there or does he go to jail, depending upon the verdict? The idea that he's already been remanded to a psychiatric facility, does that play into this at all?
Well, that could have been to establish his competency to going forward at trial. There are other issues when it comes to mental health in the criminal justice system. And yes, there's everyone knows the insanity defense. You try to prove not guilty by reason of insanity, but there's also competency. And that's a little bit of a lesser standard. And sometimes in these cases where mental health is an issue, attorneys will try and they'll try and argue that their client is not competent to stand trial, that he can't, he doesn't understand the proceedings against him, and he can't meaningfully assist in his defense.
Yeah.
So that could have been an issue why he was remanded initially, to make sure he was competent to stand trial. Doesn't seem to be an issue. He seems to understand, what's going on.
Here's my issue with this. We've talked about it before. When I've seen the insanity defense come into play and actually work, you really need a severe delusion about what is happening in your life. And but it's not always, it doesn't always work. You know, we talked a little bit earlier, there was another Massachusetts case where Michael Muko McDermott shot and killed 7 coworkers. He claimed he traveled back in time and killed Hitler and the last 6 Nazis. That's what his delusion was, and he was found guilty of 7 counts of first-degree murder, sentenced to life in prison. He's not getting out. He's no chance of parole. This guy, we don't know what that 250-page essay about why he wanted to kill Lisa Trubikova exactly said. We don't know it yet, but it doesn't seem like the same kind of thing. And if you can't get a guy found legally insane there, how would you do it here? Now, again, every jury is different, but what do you think?
You know, I think maybe from what year was that case?
That was from 2000.
2000, you know, 17 years later, the zeitgeist has changed a little bit maybe. People have a more of appreciation and an understanding of mental illness. That being said, you know, this guy's delusions in that case were pretty egregious and kind of like, you know, if anyone was insane, it had to be that guy. But we don't know what mental health experts testified in that case. We don't know, you know, maybe he was just lying. You know, what's to stop anyone from committing murder and then saying, oh, I was sent back in time to kill Hitler?
Right. It's a question of believability and if you actually take what they have to say.
Yeah, and whether they truly internally believe this thing. You know, I think this guy, his Google searches are really going to come into play.
Let's talk about that. What about those Google searches?
The premeditation. I mean, the research, and this comes into play more and more. I've seen this on some of my own cases. You know, the DA's office will get a warrant for someone's computer, and they'll take their laptop and they'll start looking through everything, and the rabbit hole goes deep. You know, people will sometimes Google, you know, about getting passports from foreign countries in advance of committing the crime. You know, that shows premeditation. That shows you understand what you're doing is wrong. You want to get out of here. I think his Google search history and what research he was doing on the internet, it's going to be very telling.
But is that necessarily true? You can have someone who has a premeditated crime, who deliberates about it, knows what they're going to do. They know that they're going to kill someone. They plan it out. But just because they plan it out, I mean, we talked about it earlier. Let's look at John Hinckley.
Yeah.
People plan out crazy events, and at the same time, that doesn't necessarily mean they're not insane, because they might be able to have the ability to plan out a crime, but they don't necessarily think that it's wrong.
Well, I think it's going to come down to the fact that he planned out this sort of this complex scheme to impede the ability of law enforcement to respond.
Yeah.
You don't plan something to impede law enforcement's ability to respond to your actions unless those actions are wrong.
Exactly.
You know, law enforcement isn't showing up and kicking in your door, you know, because they don't like the breakfast cereal you're eating.
Yeah.
They're coming for a reason, that something wrong is happening.
That's exactly the point, Ken. I think that's going to be the key to this case, is the fact that he knew the police were coming and created a barrier to them approaching him. And I think that is what is key. He knew what he was doing was against the law. And I think that's where it's really not going to work for him. But we're about to play the continuation of Officer Joshua Parsons' testimony, and we're going to get into where he talks about, and we've seen this before, what was the defendant's demeanor. And the idea we've seen in other cases where somebody commits a horrific crime, but they're calm, they're collected, they say, I did this. The idea that they don't show any remorse, that tends to show somebody might be criminally insane. They might not be criminally responsible. They might not understand the wrongfulness of their actions. So right before we see this clip, Ken, final thoughts about that idea?
I mean, I think that cuts 2 ways. Yes, this person's so insane, they don't understand that what they did is wrong. Or this person just doesn't care. Doesn't care. He knows what he did was wrong. Doesn't care.
Doesn't mean he's insane. Doesn't mean he's insane.
Yeah,
Someone could not be you know, an evil person, a cold person. Doesn't mean that they're criminally insane.
There are people out there that take human life or callously disregard it. You know, doesn't mean they're insane.
Yeah.
Just means they're you know, not so great of a person.
Right. Terrible. All right. Let's continue on with the testimony of Joshua Parsons, Officer Joshua Parsons, and we'll be back here with more analysis.
Other than what you just described, while you were still at the Roundhouse Road location?
After taking all these things off of him, myself and a trooper escorted him back down to where our vehicles were parked. Again, closer to the main road than the burning car. And at that time, I placed him in a second set of handcuffs and then placed him in the rear of my cruiser for transport.
you recognize what this is?
Yes, that's a Miranda rights card that we all carry.
Did you do something specifically with that one?
While Mr. Loya was seated in the back of my vehicle with Detective Gelson, one of our other detectives, as a witness, I read him his rights and signed the card stating myself and Detective Gelson as a witness, and he acknowledged his rights and didn't say anything about it.
Okay. Could you tell us what is it that you read to him?
I read, I am a law enforcement officer, and I warn you that before we ask you any questions, you must understand your rights. You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before we ask you questions, and to have him with you during questioning. If you cannot afford a lawyer, one will be appointed for you before questioning if you wish. If you decide to answer questions now without a lawyer present, you still have the right to stop questioning at any time until you talk to a lawyer. Do you understand what I have read to you? And having these rights in mind, do you wish to talk to me now?
And how did you respond to those last two questions?
He stated he understood his rights, and then he just didn't state anything else.
Objection.
I'm sorry.
No objection.
Next number, so.
What's the next thing that happened?
At that time, myself and a Falmouth officer drove Mr. Loya back to the police station in the cruiser. And
Which cruiser?
I believe it was Y22.
Which is what?
A marked police cruiser.
Okay, go on.
Drove him back to the station. Once at the station, we brought him in through the Sally port and directly back to the holding cells.
And then what happened?
We took all of his clothing off for evidence and gave him a pair of blue paper scrubs to wear and placed him in the cell.
Oh, by the way, do you see Mr. Lawyer in court here today?
Yes, I do.
Could you point him out for us, please?
He's seated next to the defense attorney.
May the record reflect he's identified the defendant, Your Honor?
So noted.
And
Stated that he was acting alone and that all the other bombs that were placed about the complex were supposedly hoaxes. He also stated that he had dropped a backpack or a duffel bag full of smoke grenades and other alarms during his travel through the complex. And I put that out over the radio so that other officers could approach it with safety.
that was at the scene.
That was while I was searching him at the scene, yes.
I'd like to look at this question. Do you recognize what this is?
The outer jacket that he was wearing.
I don't know.
No objection.
Next number, exhibit 14.
What was the temperature?
It was well below freezing. It was around 10 degrees.
So after Mr. Lawyer was brought back to the station and these items were recovered from him, what's the next thing that you were involved in, if anything, with this case?
After placing him in the cell, other detectives had come back to the station at the time, and Mr. Loya was asked if he would like to do a recorded interview, and I was in the room for that as well.
Okay. And if I might just ask you to look at this, can you tell me what this is?
This is a Bourne Police Department form for rights in recording. It advises, again, the Miranda rights. Ask the...
Okay, so that's a Miranda rights form?
Yes, it is.
And was something done with that with respect to Mr. Lawyer in your presence?
I signed it as twice for both Miranda statements being read and that he consented to being recorded.
Okay, so that was done in your presence?
It wasn't done in my presence, yes.
So tell us what was read to him, what, if anything, did he do or say?
You want to read from the sheet? Or?
Yes.
Okay. At this time, I'm going to tape record you being advised of your rights. After you have been advised of your rights, it will be your decision whether the interview will be recorded. I'm going to ask you to initial and sign this form after you read your rights. Miranda advisements. Before asking you any questions, it is my duty to advise you your rights. You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to talk to a lawyer for advice before we ask you any questions, and you may have a lawyer with you during questioning. If you cannot afford a lawyer and want one, a lawyer will be provided at no cost before any questioning. If you decide to answer questions, you will still have the right to stop questioning any time. If you understand each of these rights as I have read to you, and has a box marked yes and a box marked no. The box marked yes is checked, as well as initials for Mr. Loya next to it. And having these rights in mind, if you wish to speak to me now, there's also, again, a box yes and no. At that time, there's nothing checked off. Second part of the form, tape recording. There's a policy of this department to record all interviews so that there is a recording of our discussion. There are potential benefits to the electronic recording of any interviews. For example, the electronic recording of this interview will create a complete record of what is said to you today and what you said in return. At your request, we will conduct this interview without any further recording of your statements. Be advised you may change your decision at any time during this interview. Do we have permission to tape record our discussion? There's a box marked check. There's a box marked yes, which is checked. I agree to have this discussion recorded, as well as Mr. Loya's initials next to it, his signature below it, my signature as a witness, the date and the time.
Okay, and again, you observed him to sign that form, is that
Yes, I
correct?
did.
Now, who read that to you, if you remember?
I don't recall who read it to him.
Who else was in the room when that was done?
Myself, Detective Doble, I believe Officer Spillane was there as well.
I got this, Your Honor.
No objection.
Next number exhibit. 28.
And then there was an interview of Mr. Loya?
Yes, there was.
And basically, who conducted the interview at that time?
At that time, it was mostly Detective Doble. I believe at some point in time, Detective Gelson may have arrived as well.
Okay. Were you present when anybody from the state police arrived?
Yes, I was.
And who was that?
Trooper Jerry Donovan.
All right. And did he actually actively conduct some of that interview?
Yes, he did.
All right. Your role is more of just observing after witnessing the signing of the rights form, right?
Yes, it was.
Welcome back to Law News Network. I'm Jesse Weber. You're watching testimony from the Adrian Loya case out of Massachusetts. Again, this is Loya, who's a former Coast Guard member, who's accused of forcibly entering the home of Petty Officer Lisa Trubnikova and her wife, Petty Officer Anna Trubnikova, and then going on a shooting rampage, killing Lisa and injuring Anna, as well as responding Officer Jared McDonald. Prosecutors say Loya videotaped this entire rampage with a camera that was attached to his clothing. He's been charged with 30 counts, including murder. I'm here with Ken Belkin to talk a little bit about this case. Ken, question, before I sneeze.
Question. Thank
you. Question. We were seeing the prosecution call Officer Joshua Parsons lay the foundation, exactly the entire process about booking someone. Their search of him, the arrest of him, Miranda rights, just to provide our viewers a little bit of understanding about how important is that in a trial to establish that everything was done by the book and was appropriate, because as we know, if something's a little off, it can lead to the end of a trial. Please explain.
Yeah, I mean, look, this is extremely boring stuff to listen to if you're on the jury.
Especially when you know who did it.
Yeah, when you know who did it. And there's not much in dispute here. But, you know, as with a lot of things in the legal profession, it's a lot of boring stuff, you know, and it's a lot of walking things through step by step by step by step, and it just gets a little tedious. But it is, you know, they have to make a complete record. These transcripts, at some point, I mean, I guarantee you, this guy is going to appeal the results of this trial on several grounds.
Well, if he's found guilty and not criminally insane.
If I were a betting man, you know, I'd be betting my right arm that this guy is going to be found guilty. And look, his attorneys, he's going to appeal it. He's going to have nothing to lose. He's going to be sitting there in jail for the next 25 years, maybe more. He's going to appeal it. He's going to throw the spaghetti at the wall and see what sticks. And I don't blame him. If I were in his position, I would too. Nothing to lose. So all these things are that this record needs to be totally complete. And, because eventually these transcripts are going to be reviewed by the appellate attorneys and the court, the appellate court.
And determine if anything was done in an unconstitutional manner.
If
his
there's
search,
any legal grounds.
Exactly. And we're going to hold you to that right arm. And if we do find that he is criminally, if the jury does find that he's criminally insane, we're going to have a live airing of the chopping of your right arm. We're going to put it off to the side in the refrigerator, and we have it on tape. We have it on the record.
Aaron Keller would gladly be the executioner of that sentence.
We'll have to see. Okay, so we saw the direct examination of Officer Joshua Parsons, but now let's look at the cross-examination, which is what Ken and I were talking about a little bit. We have the responding officer here. So what will the defense do when they cross-examine him? Let's take a look, and we'll be back here with more analysis.
Officer, you had heard a brother officer that the Jared McDonald had been hit. And then you went further down the road because of the snow impeded your progress from cutting through the cul-de-sac. Is that fair?
Yes.
You continued up the hill until you started to descend the hill when you first saw somebody, that being Mr. Loya. Is that fair?
To the right, to the left of the fort?
Yes.
Yes, I did.
And your words were, sir, you indicated somebody was coming out, a gunman. Remember using those words?
Yes, I
When
did.
you first left? You didn't have any weapons on at that time, right?
At that time, no.
You approached, in fact, and you and other officers gave him some instructions, true?
Yes, we did.
And in terms of those instructions, get on your knees first, right?
Yes.
Get on your stomach, right?
Yes.
And it was coming out over to you again from, we have K-9 Officer Martin and another fellow as well. They're now closing in on Mr. Loya. Fair?
Yes.
And at that time, sir, fully and wholly compliant with any and all of your requests, true?
Yes, he was.
And then you proceed to then drag him off the roadway again, concerned for your safety and that of other police officers, true?
Yes.
And again, fully compliant with any and all of your requests, true?
Yes, he was.
And was he also responding to you at that time? I mean, yes, sir, no, sir, do you remember that?
He was responsive to questions, yes.
Okay, not only responding to questions, he was doing so in my manner. No, sir, yes, sir. Is that fair?
Yes.
Okay. And in fact, not only was he cooperative, he was always, my words again, compliant with your requests, right?
Yes, he was.
In fact, you asked him about, for your and other officers' safety, about a second gunman, right?
Yes, I did.
And in those slew of questions, sir, there was no Miranda rights at that time, right?
At that time, no.
Yet he responded, there's no second gunman, fair?
Yes.
You were asked about what you determined the M&M bottle, that may have been some type of explosive device, that they were just hoaxes, right?
He stated that, yes.
And when he was stating that to you, he did so in a monotone voice, didn't he?
He wasn't excited, if that's what you mean, no.
Yeah, well, I was going to ask you that. What was his demeanor?
I'd say overly calm.
Okay. Because obviously your adrenaline, a brother officer just hit, other officers converging, you're finding out there's bombs and other gunmen. You're excited, your anxiety's up. Is that it? Is that fair?
That's accurate, yes.
But he again was, your words please, overly calm?
Yes, overly calm.
Okay. Now, I think it was Detective, if I said it right, Silvestro, who indicated double cuff him. It was Silvestro, Officer Silvestro,
Lieutenant, yes.
Lieutenant, asked you to put another set of handcuffs on the fellow, right, and take him down to the station with a fellow from Falmouth,
Yes.
right? Who was that, Falmouth officer?
I believe it was Officer Hazelton.
Okay. And you bring him back to the Bourne Police Department at that time, right?
Yes.
Now, did you have a conversation with him on the way?
No.
No, how you doing, how the Red Sox, nothing?
Nothing else.
Okay. And who receives you? In other words, who was back at your station when you bring him in?
When we first arrived, it was, I believe it was just a dispatcher that was in the station. That was the only person there at that time.
Okay, no other supervisor, Wallace
No
Perry?
supervisors there, no.
Very good. Now, who instructed you, or did you do it on your own, sir, to remove the clothing?
I don't recall who instructed to remove the clothing.
Okay, was Officer Spillane there?
He was there, yes. He
Okay.
arrived as we bring him in.
And did you ask him to take his clothing off at that time?
Mr. Loya?
Yeah.
Yes, we did.
Okay, and he just removed his clothing as you and I would at the end of the day?
We didn't let him just take everything off at that point. We helped him take it off, yes.
Well, when you say helped him take it off, you held him against the wall and cut it off, right?
I don't remember using a knife to cut anything off him, no.
How did the clothes come off?
We took his pants off and took his...
Okay, nothing was ever cut or ripped off? Is that what you're
I don't
saying?
believe so, no.
Okay. You indicated that at some point after he's given those, what I'll refer to as those hospital scrubs, the blue clothing, you remember him putting those on, you indicated he was asked to do a report. Those were your words, right?
He was asked for an interview?
Yeah.
Yes.
I mean, that's what you took him in for an interrogation, right?
Well, I didn't personally take him in. He was asked in my presence if he wanted to do a recorded interview.
And what was his response?
Yes.
And how was his demeanor at that time?
Calm.
Overly calm again?
For that situation there, just regular calm. We're not in the same situation anymore.
Okay. But he's using the same tone of voice as you and I right now.
Yes, he is.
And he indicates, sure, let's go back and talk, right?
Yes.
And back there is Officer Spillane on one side, and you're on the other, true?
Yes.
And the senior officer is Detective Doble, he's in the middle, right?
Yes, he was.
And Mr. Lawyer, by the way, we have a video of this. We have a video of
Yes.
this, right? And Mr. Lawyer is sitting there answering any and all questions, right?
Everything we asked.
And everything you asked. He was offering stuff up too, wasn't he?
He was compliant. Yes.
Well, overly compliant. He told you the whole story, didn't he?
Yes, he did.
And not only to the senior officer, Doble, but on occasion, Officer Spillane would ask him questions, and he'd continue to speak, right?
I believe so, yes.
Okay. And how long was it until Trooper Donovan arrived?
I'm not sure the exact time.
What time did you get back to the station, if you recall?
To be honest, I don't recall the exact times of being back in the station.
Well, you spent better than an hour with the fellow before Trooper Donovan arrived, right?
It may have been the case. Like I said, I don't have the exact times.
Well, you got...
The video will show the
And you
times.
got the whole story from him, about what happened, what he planned and all of that, true?
Yes.
And that emotionless state stayed with him the entire time. Is that fair?
Being calm, yes.
Yeah. And there was no emotion. It was flat. He was flat the whole time, wasn't he? Is that fair?
Aside from being calm, I really couldn't speak to the
Okay.
people.
And now, you stayed in there when Trooper Donovan arrived, right? The representative from the state police, or what we call the CPAC unit, true?
Yes, I was there.
And Officer Donovan, pursuant to his training experience, started anew, didn't he?
I believe so, yes.
Well, when you say you believe so, you were sitting right there, weren't you?
It's been 2.5 years. I don't exactly remember his exact conversation with him, no.
Okay, but is it fair to say he started the whole story over again about what happened that evening and the preparation for it, sir?
You'd have to ask Mr. Donovan.
Okay, you don't remember?
I don't remember exactly
Okay.
when the story started again, no.
And sir, how long have you been a police officer?
5 years.
And pursuant to your training experience and doing interviews and speaking with folks, whether it's roadside search and so on, did you have the opportunity to view him and see if he had a note of alcohol on him or any other substance?
He didn't know.
Okay, so you have the opinion as to the state of his sobriety?
He was sober.
Okay. Nothing further, huh?
Anything further on this witness?
So, when you were asked about when you first saw Mr. Lawyer coming towards you, you didn't know if he had a gun then, did you?
I was not the first person to see him, no.
And when you asked him any questions during the entire time he was in your presence, he would respond appropriately, wouldn't he?
Yes.
Thank you, that's all I have.
Nothing.
Thank you, sir. You may step aside.
Thank you, Ron.
Joe?
Welcome back to Law News Network. I'm Jesse Weber. You're watching again the testimony of Joshua Parsons, who was one of the responding officers in the Adrian Loya case out of Massachusetts. Ken Belkin's here with us, but not for too much longer. I'm sorry, Ken. We only have you for a little bit more today. But we are talking about this case. What you were just watching, Ken, was Joshua Parsons being cross-examined by the defense. From what I saw, they were asking him questions about what was Loya's response to the responding officers. Was he compliant? Yes. Was he calm? Yes. Issues of that. What were they trying to do in that cross-examination of Officer Parsons?
I mean, it seems to me like they were trying to kill time because there's not much you can do here. You know, there's really not much to impeach this arresting officer on. You know, I did think it was interesting. My interpretation is that the defense took a bit of a combative tone with this officer, which I don't know that I would have done, because I think that's something that could potentially, you could lose some jurors on. There's no allegations that this officer did anything wrong. There's no reason to be rude to him or, you know, anything less than polite.
Well, especially since these witnesses have to stand. It looks like they're in like the old England grounds, accusing him of something. Very strange, very strange.
But look, this officer comes across as very sincere, very nice, very articulate. He comes across as everything you would probably want in an agent of law enforcement.
So here's the rationale that I think the defense is going with here. I think this is the strategy. If you can show that your defendant was extremely calm, extremely compliant, did not cause any kind of disruption, and you say that this was a person who was being arrested by the police for a heinous crime, and if you can show that he showed no level of emotion, that he was calm, compliant, he's actually criminally insane. What do you think?
Yeah, I don't think so. I mean, I think really what a jury wants to hear when someone's insane, they want to hear that it took 5 officers to take this guy down. In his interrogation, he's throwing his poop at the wall.
Yeah.
You know, that's what they want.
But you're not going to get that in every situation.
You're not going to get that in every situation. And I just don't know that going down the route of, look, he was so calm and cool and collected, he had no idea. No, he was calm and cool and collected because he didn't care.
Yeah.
That's my interpretation.
So there's a difference between someone being a sociopath or someone who is a cold-blooded killer as opposed to someone who is so criminally insane under the standard that they don't appreciate the wrongfulness of their actions.
Being a sociopath or being a psychopath, it's not a mental illness. It's not something that's in the diagnostic and statistical manual that it classifies someone as having a mental illness. It's just, you know, you're a psychopath or you're a sociopath.
We're looking at the law in Massachusetts. What's the law in New York about this? And have you had experience with criminally insane?
Yeah, I've had 2 cases. One was a case when I worked for a firm. We were preparing a murder case and we were using, you know, mental health defect as the insanity defense. In this case, this guy, and like you said, it's so rarely deployed successfully. Jurors just do not believe it. This guy, in addition to having a drug problem, he had been in and out of mental health facilities over the course of like 20 years, and really very bad paranoid schizophrenia, and he was convicted.
Yeah, and it's different here because this guy was in the Coast Guard. This was a guy who was an upstanding, well, seemingly an upstanding member of the community, doing his part to help people, and then all of a sudden commits a heinous crime. For the motive is still a bit confusing. We have one side saying, the prosecution saying that this is a man who was obsessed with Petty Officer Lisa Trubnikova. Yeah. The defense is arguing that, well, this is a guy who had previously reported on her when they both served in the Coast Guard for sexually assaulting him, and this is a revenge killing. How important is the motive here in terms of why this happened?
I mean, I don't know that the motive is so important. The motive, you know, it's not an element of the crime's motive. I think it's just fodder for the jury.
Yeah, I agree with you. And let me ask you this. From a practical standpoint, we have 30 counts, okay? 30 counts in this in original indictment. We have murder, armed assault to murder, aggravated assault and battery, armed home invasion, armed assault in dwelling, use of a firearm in the commission of a felony, armed kidnapping with serious bodily injury, burglary and assault on occupant, arson of a motor vehicle, possession of a hoax device, assault and battery on a police officer, and possession of a large capacity feeding device. And there's obviously several counts within that.
Yeah.
How long would a jury deliberate in this case on all of these counts?
I mean, look, I'm surprised they didn't pare it down for the jury and just, consolidate it and dismiss some of these counts, because this is like, the standard overcharging that prosecutors' offices indulge in. At the end of the day.
But isn't that always when they don't have a strong case and they try to see whatever sticks?
Oh, they do it always.
Oh, they do it always.
Strong case, weak case, it doesn't matter. They throw the book at people. But I'm surprised, for the sake of the jury, that they didn't pare it down to 5 or 6 counts. Because 30 is a lot to deliberate on.
So that's a problem for the prosecution in what sense? You say that the jury is just going to combine things together, that they're not going to give it a fair shake? What exactly?
I think inevitably this guy's going down no matter what.
Okay.
I don't think the prosecution has many problems in this case.
Yeah.
The extra charges, not going to be a problem, because at the end of the day they're going to get him. Belkin's prediction: first-degree murder, guilty.
We've said it. You said it earlier. That right arm is coming off here on our network.
Good thing I'm left-handed.
Yeah, good thing you're left-handed, because we're chopping that right arm off if, in fact, he is found criminally insane.
And I heard there's a rumor Aaron Keller is going to be the one swinging the axe.
We'll make sure we get him on to do it. All right, Ken, thank you so much. I don't know if we have any more time with you today, but hopefully we do. We'll see how long a couple more clips
Well, thanks
are.
for having me, Jesse.
Of course, a pleasure as always. We're going to continue our